Welcome. In this video lecture, we're going to go over criminal justice and criminal law. In previous lectures, we've talked about the different types of crimes, defining what does it mean murder, assault, battery, burglary, robbery, and we've gone into things that are mostly focused on penal law. In this one, we're going to distinguish certain aspects of criminal law from penal law, such as things like criminal procedure and how things go through the criminal justice system. So we're going to look at that and look at those different aspects. The second thing we're going to look at is we're going to compare the adversarial with the inquisitorial system of legal systems. So the adversarial one is the one that you generally know that operates in the United States, where you have two sides and a judge that kind of presides over the trial and a jury that determines, let's say, the issues of fact in the trial. And so we're going to go to that and just compare that with some other systems around the world that are called inquisitorial systems. And finally, we're going to look at what are called victimless crimes, because I think this is a generally set of crimes that have a certain nature, character, structure to them that kind of leak over into some of the civil law and how criminal law can impact civil law and business law as we go forward through this course. So let me just start with the agenda, just recapitulate from the top. So what we're going to first do is what are the different elements of criminal law, and particularly we're going to distinguish between criminal procedure versus penal code. The penal code is different and varies from state to state and jurisdiction to jurisdiction, and basically defines what a crime is, what are the standards, what sentences are attributed to different charges, etc. Well, criminal procedure kind of sets up the rights in trial, the use of evidence, things that can be excluded, and making sure that due process is, let's say, guaranteed and respected. The next thing we're going to look at is how the American criminal justice system differs from other countries, which means that we have a system, and it's probably very familiar to us, where you have things like reasonable doubt, innocent until proven guilty. We have jury trials. We all expect that these are kind of the obvious and universal ways that criminal trials are conducted, but in fact, they're pretty unique to what you might call the Anglo-American system, or systems that have a common law background. And what this means is that, in the English-speaking countries of the world that all get their legal systems mostly from England, but also influenced by the United States, we have one type of legal tradition. There's another legal tradition that really kind of starts in Europe, and you might associate primarily with the legal system of France, but is also common through most of the world through the colonies of Western Europe, but also found in East Asia as well. That's called an inquisitorial system, and we'll talk about how they differ. Now, there's no pure adversarial or inquisitorial system, so we're talking about, abstract systems, not specific countries. But it kind of we'll go over kind of the emphasis in each case and try to kind of point out what their strengths and weaknesses are. And lastly, we're going to talk about victimless crimes and particularly how these could affect business. Now, usually the term victimless crimes talks about crimes, moral crimes, things like drug use, sex crimes like prostitution, but they also kind of characterize most types of what you might call white-collar crime, and white-collar crime being a major source of criminal law that affects businesses. It's important to look at that and what that means for how the criminal justice system can influence, let's say, business operations. Okay, so the first thing I want to do is distinguish between what's called the Penal Code versus, usually what's called the Code of Criminal Procedure. It has slightly different names in different states and different jurisdictions, but more or less they're focused on the same thing. So when we talk about criminal law, or what's sometimes called penal law or the Penal Code, you're kind of set out what are the rights and obligations for different individuals in society, and so this is where we define what crimes are. So what is murder in the first degree, what is assault and battery, what constitutes robbery and burglary, and even though I think we have an intuition or a common sense of what those are, legal codes write them down. So the point is that you have to prove certain things to meet, let's say, this particular charge. There has to be certain circumstances around a crime that makes it fit, let's say, first versus second degree murder or other things of that sort. And so what you're trying to answer are the questions: did a defendant commit a crime? And then more or less is, did the actions of the criminal, or did the actions of the accused fit, let's say, the definition of the crime as it's written down in the penal code in the criminal law? The second thing is, what crime did the defendant commit? So, for example, depending on different aspects of the crime, whether there was intention, whether there was injury involved, and you kind of did this before when you were looking at, what kind of case it is. We might know that someone is injured. We know there's a crime there, but we don't know which crime it is. So whether it's manslaughter versus murder, whether it's robbery versus burglary, depend upon the nature of, let's say, the details of what occurred. And lastly, the Penal Code might lay out some types of defenses. So, what are the standards for um, justified homicide? What are the standards for something like stand your ground? And these differ from state to state. So, for example, your ability to use or the right to self-defense is very different in New York than it is in some other states in this country because of what you might call what are called castle doctrines, which means your ability to protect your own home. Um, there are things such as what I might call um, laws that basically allow you to stand your ground, which means that if you feel threatened, you're able to you retaliate. And as I said, different states have different standards for this, and that's where you can find these and find where these standards are generally in their what are called criminal law or in the penal code. And there's sometimes where you might have overlapping jurisdictions where at one level of the jurisdiction something is legal and another level something is illegal. And what you see this mostly is in the legalization of controlled substances like drugs, where some states have legalized marijuana, which means it is not a crime for the state, and let's say state law enforcement won't, let's say, does not have the power to investigate or arrest for those crimes, but these might still be illegal at a federal level. So, for example, even though most states have decriminalized marijuana, it is still, let's say, a federal crime because it's still on their list of controlled substances, and as a result, you could be arrested by a federal, let's say, criminal justice agency and prosecuted in a federal court for violation that, even though the state says, well, we're going to decriminalize it and we're not going to, this is no longer a crime. Now, in contrast, you have what are called, criminal procedure or the Code of Criminal Procedure. And what this is mostly concerned with is what are the individual's rights during the criminal process. So the point is, what evidence could be brought against you in a trial? So, for example, if the evidence was illegally obtained, or let's say there wasn't a search warrant, what could happen is your lawyer could make a motion and say, well, this evidence cannot be presented to the jury because it was obtained illegally. And as a result, the jury might not know, let's say, all the facts of the case because some evidence is excluded. And the standards for excluding evidence are put in the Code of Criminal Procedure. There are other things, for example, like how the person was detained. For example, like they're not allowed to hold you for a certain period of time without laying charges, whether the interrogations were conducted legally, were your rights violated during, let's say, when you were in custody, and things of that sort. And even on top of that, whether the trial itself was conducted according to the stated procedures. So, did the government who's acting in terms of, let's say, the case of a criminal act, did it act legally according to the rules and procedures that are laid out? Now, some of these are, enshrined in the Constitution and your rights of due process. Some of these are also written in particular states, and particular courts have different procedures, and therefore there might be additional protections. So, for example, there are some things with minors that there has to be an adult present when they're being interrogated by the police. The question of whether that comes from the due process amendments in the Constitution or whether that's a feature of different states' Code of Criminal Procedure can vary from place to place. So let's talk a little bit more about what the Penal Code does. So the first thing is it sets criteria and standards for crime. For example, does there need to be criminal intent? What are the different thresholds for different property crimes? So, for example, larceny versus robbery might be about partially about what is the value of the items taken in the property crime. So that might be defined. In cases of like murder in the first degree, murder in the second degree, they might list certain types of crimes that fit different categories and therefore are associated with different potential punishments for a guilty verdict in that. So, for example, in New York State, spree killers, serial killers, killing members of the criminal justice system, so killing police, witnesses, judges, prosecutors, is first degree, regardless of all the other aspects of the case. Assassination would count that. Contract killing would be first degree. Most murder cases are not murder in the first degree. They're homicide cases, but generally they're second degree because they're missing some important aspect. There's either not clear intent, there's not, let's say, a malice aforethought and things of that sort that would make it meet a murder in first degree charge. Now, in other states, they might define this slightly differently, and that's because their penal code is different. Secondly, the penal code might classify the crime. So there are different classes of felonies, and there are different types of misdemeanors. And because these have implications for, let's say, being on your record, and if you are found guilty of a felony versus guilty of a misdemeanor versus guilty of a traffic violation, this has different implications for what you might need to report or what you might need to communicate to employers. These are classed in the Penal Code. The next thing the Penal Code does is that it's going to provide sentencing guidelines, which means it's going to set minimums and maximum punishments for different crimes, which means they're not going to be able to, whether you can do concurrently, whether you're going to have consecutive sentences, what is the minimum that you can be punished for a guilty verdict. And so usually there's a sentencing phase in most trials that occurs after someone is found guilty or not guilty. And then, the Penal Code will kind of give direction of what is the range. And generally that might be decided by the judge or sometimes decided by the jury depending on different features in the case. So the Penal Code interacts with some other things, because sometimes you might think the Penal Code is not complete. It doesn't define certain aspects, like what does intent mean in a particular crime. And so it interacts with the common law, which are the previous precedents and decisions by trial judges. And this goes back to before the founding of the United States. It might go back to English courts. And so if something is not defined in the letter of the Penal Code, what you might do is go back to the common law and try to find out what do different definitions mean, what are the standards for evidence, and if something doesn't clearly fit into a particular category of crime because it's unique or the circumstances are really strange, you might use the common law to inform what is going on in a criminal trial. The other thing, in the 1960s, the American Legal Institute created what's called a Model Penal Code. And what this is trying to do is create a consistent template across all the different penal codes and penal laws in different states and jurisdictions, so that using similar definitions, similar punishments, etc. And so sometimes, even though this is not law, it's not passed by a legislature, people will consult this, and many states have adopted what's called the Model Penal Code as a way of simplifying, let's say, their penal code to make it more understandable and more usable in everyday criminal justice. So the Code of Criminal Procedure kind of sets the procedures through which violations are adjudicated, which means that now that we know that we have a crime, what procedures does the criminal justice system have to follow, whether it's police, prosecutors, trial courts, or corrections. And so the point is that how are these things going to be decided? And so there might be that there are different phases in a criminal trial. So for example, there might be a grand jury before the trial jury. There might be the ability to make different motions, such as forming the jury and choosing jurors. There might be something about motions about evidence that will be allowed in the trial. And so the Code of Criminal Procedure lays out what these are and what procedures that the state has to go through to go from, let's say, an accusation of a crime through the conviction at the end of, let's say, a jury trial, as well as the sentencing. The key thing here is that establish the rights of the accused in the criminal process, which means that you might be, in a sense, factually guilty of a particular crime, but the point is you still have rights to protect yourself, and therefore you don't have to testify against yourself. You can have Fifth Amendment protections. You might have protections against, let's say, cruel and unusual punishment. And there are various rights in terms of particularly how evidence is collected, and how what evidence that, if, let's say, for example, the prosecution has evidence that is exculpatory or kind of suggests that you're innocent, that they have to make that evidence available to the defense. And so the point is that you might have certain rights in the process, and these are not respected. They might declare a mistrial, or they might invalidate the outcome of the trial. They might have a mistrial, and this all depends upon the nature of individual cases. The second thing that criminal procedure does is that it generally sets evidentiary standards. So there's something usually called an exclusionary rule, which means that evidence that is not properly collected or evidence that is not properly maintained might be excluded from the trial, which means it cannot be considered by the judge. It cannot be considered by the jury in determining the facts of the case, even though that this evidence might be out there, and even though this evidence might in fact be valid and reliable, because it was collected or it was handled in an improper way, it can't be used in the trial. So for example, if you have an illegitimate interrogation where someone, let's say, admits to being guilty of a crime, if you have, for example, evidence that is falsified, or evidence that is damaged, or evidence that is collected without a proper warrant, those can be excluded. Now, this is kind of a gray area because, what police are able to do or not do has changed in terms of different Supreme Court rulings in the last 20, 30 years. So generally, before the 1960s, the due process was generally interpreted in a way that was very favorable to law enforcement and criminal justice. In the 1960s and 1970s, there was a lot of cases where the rights of the accused were strengthened. Recently, those have been, let's say, watered down somewhat. So it's kind of unclear where we are in the flux of, let's say, what are your due process rights, although people generally agree upon the general principles involved. It also might set, like, for example, standards of proof, which means, are you determining in certain cases the preponderance of evidence, which means kind of more of a probability? Are you probably guilty versus probably innocent? So what does the evidence suggest? It doesn't mean beyond a reason. Most criminal trials have a standard that sets beyond a reasonable doubt. And so now we're going to talk about two broad models. And generally you have what's called an adversarial system, which is the United States is the classic example. And then you have what are sometimes called inquisitorial, but probably more accurately non-adversarial systems in what are called the civil law countries. And civil law countries generally are, as most of Europe, a good part of Africa and East Asia, as well as Latin America. Now, there are very few pure inquisitorial systems, as I'm going to describe them going on, but most of them have legal systems, have aspects of this. And just to one little side note, there are two kind of local systems that have elements of the civil law, although these have changed over time. So the state of Louisiana, because it has kind of a French background, has a civil law versus a common law tradition, which means that judges don't, at one point in time, judges in Louisiana could make individual determinations inside a case about what the law was, and they didn't have to necessarily respect precedent or decisions made previously in the common law tradition. The other one is the province of Quebec in Canada. Once again, because of a French tradition, they have, let's say, a mixture of a civil law tradition with some aspects of what you might recognize as the American or Anglo-Saxon or adversarial legal structure. So this kind of just to go a little bit more in the Code of Criminal Procedure and just show you how a case might flow through the criminal justice process. So first of all, you have the commission of the crime. It has to be reported, observed. There needs to be an arrest made. There'll be an investigation. And what I think this is just, I'm not going to go through every single stage here, but the point is that there's a whole series of steps before you go from arrest to trial. It's not very common that, let's say, crimes committed and the trials occur. And actually, during the pandemic, because of safety measures, a lot of criminal trials were suspended, which means because you couldn't have all the people clustered, meaning the jurors in a small room talking to each other, for a long time, a lot of criminal trials were suspended. And they've just recently started to restart some of these criminal trials that started before the pandemic started. And so a variety of different ways is that you can follow different pathways, whether it's a felony, misdemeanor, different types of motions that can be made, particularly for juveniles, although this is once again changing, is that juvenile offenders go through a different system that has a different standard, because generally the charge in a juvenile justice system is the welfare of the child, as opposed to guilt or innocence, and as a result, you might not have some protections, or you might not have a right to a right against self-incrimination. You might have to cooperate, because the way that a lot of juvenile systems has aspects of an inquisitorial system where the judge will ask questions and do research and collect information about the case, and you can't, in a sense, not cooperate. In a sense, you can't be a non-cooperating witness if you're going through a juvenile process. And as a result, there's some limitations on what types of penalties and whether records or outcomes can be sealed and become quote unquote your permanent record. But this is kind of just an idea of all the different steps that have to be taken before someone is incarcerated. And even though it might seem like one flows into another, there's a lot of different times where motions have to be made and decisions have to be made, and a lot of, let's say, discretion inside the American criminal justice system. So, adversarial versus inquisitorial. So, if you look at this map of the world, you can see that most countries have what's called the civil law tradition, and the inquisitorial or non-adversarial legal system is generally considered associated with the civil law tradition, although every civil law tradition is slightly different. So, if you look at the countries in pink, which are the United Kingdom, Canada, the United States, Australia, India, East Africa, these are basically England and former English colonies. Have what is called the common law system common law legal system. Well, if you see all the countries in kind of the blue, including almost all of Europe, almost all of Asia, West and Central Africa, and Latin America, are based on a civil law tradition, and therefore might have more of a non-adversarial or an inquisitorial system in terms of how they conduct criminal cases. So let me just go a little more deep into detail on what an adversarial system is. The key thing is how it conceives of the legal process, and a trial is basically a contest between two adversaries. And you might want to think of that, even though it's not a game, you can think of it as a game. And the key thing about this is that the game has to be fair. There can't be, let's say, the process can't favor one side over the other, which means that both sides should have the same rights, the same powers, the same ability to interrogate evidence, and therefore there can't be bias in the system. And so the emphasis in an adversarial system is not necessarily on truth, but on fairness and justice, which means that there has to be a fair process that is fair to both the defendant and to the prosecution. And therefore, when they're making decisions, they're going to emphasize fairness, even if, let's say, that means excluding some information that might lead to the truth of the case. So truth versus justice, and to the extent those are different things, they're kind of divided inside an adversarial system. So you might exclude evidence that might, convict someone because it was improperly contained and therefore was not fair to the defendant in the case. So some of the things that you see in adversarial systems that kind of promote this idea of justice and fairness in the system, and I'm not saying the system is fair. I think there's a lot of problems and bias in the system, but the point that in concept, why these things happen is because they're thought to serve the purposes of justice and fairness, are things like discovery, which means that as evidence is discovered, the evidence has to be made available. You might need to declare potential witnesses. So the point is, you might see in TV shows where there's a surprise witness at the end. Generally, this does not happen in terms of, let's say, most actual criminal trials, because there's a list of witnesses so that the defense can prepare and do research and, let's say, know that this witness is coming and therefore might have an idea of what this witness might say. And so you'll have a list of potential witnesses that will be brought and evidence exhibits that will be presented in the trial. And that the evidence is collected according to proper procedure, which means the warrants were proper, the evidence was handled, the chain of custody was maintained, and a variety of different things. That means the evidence wasn't tampered and was collected legally by police and by prosecutors. Generally, there is a standard of innocent until proven guilty, and what this means is that someone is presumed to be innocent, which means even if you never say anything as a defendant, you don't have to defend yourself. The burden of proof is on the prosecution to prove that you're guilty, not the burden on the defendant to prove that they're innocent. And as a result, the point is that there's a standard of guilt that is a burden of proof on the prosecution to present the evidence. And it's possible that if they don't meet this burden of proof, the case could be dismissed because either there's inadequate evidence or there's no way to even reach what you might call a minimal level of evidence to support, let's say, a guilty charge. Another aspect of the adversarial process is examination and cross-examination, which means that both sides have the ability to interrogate the witness and interrogate the evidence, which means the evidence is not just presented in a one-sided way as like received facts by, let's say, the prosecution. The defense can challenge every witness, the defense can challenge the evidence, and this back and forth goes on. And what you'll see later is that this is not the case necessarily in inquisitorial systems, where the judge might do the research on the case, and as a result, the point is that not everyone has a right to interrogate or challenge the evidence. So one more thing is the role of the judge is kind of different in an adversarial system, and in the adversarial system, the judge is not supposed to intervene. The judge is kind of a neutral umpire. They're not trying to, let's say, impose their opinion or their views on the case. All they are doing is to make decisions upon matters of law. And that means what the judge is mostly, when you have objections and things of that sort, it's not objections to the facts presented by witnesses. They're objections to the form of questions. They're objections to the use of certain evidence. And so they're making decisions based upon the Code of Criminal Procedure and evidence, and not about, let's say, and they might, let's say, read or explain what the definitions of the Penal Code are, but they're not saying these are the facts of the case. The other part to it is that, so while the judge determines matters of law, the jury decides matters of fact. What actually happened in the case? What was the intent? What was the act committed? Who committed the act? But once again, the jury is passive. They can only listen to the presentation of evidence or the interrogations done by the prosecution and the defense. So if a jury member has a question, they might be able to ask the judge about a matter of law. They might say, what is the standard we have to meet? Or can you explain what the penal code means? But they can't, let's say, ask witnesses questions. And so there are things that the jury members might want to know, but these are not going to be presented. And as a result, they might be quizzical or in the dark, or maybe not fully understand things going on. And in some ways, there might be evidence that everyone else knows, but the jury does not know. So, for example, many of you mentioned the most famous legal case that you were aware of was the O.J. Simpson trial. And what happened in that case is that many people were watching the trial, and so they were aware of all the evidence and motions made by the attorneys and what was being reported in the news media. But the jury was actually taken out of the room and didn't hear some of the evidence that everyone else was aware of. And as a result, they couldn't ask follow-up questions. They maybe didn't know what other people thought they knew about the case. And that's, let's say, makes a big difference in terms of that the jury is passive. It's not allowed to interrogate the witnesses or interrogate the evidence presented to them. Now, in an inquisitorial system, the key aspect is that it's not about fairness or justice per se. It's about a search for truth, which means that the standard for what is allowed and not allowed is whether it serves in discovering the truth of a case. The word inquisitorial system is kind of related to an inquest. When you conduct an inquest, you're trying to find out what happened, and therefore you might empower someone to go and establish the facts of the case and be kind of more of an investigator. Generally, if you are an inquisitorial a process that has aspects of the inquisitorial system, you might not be able to not cooperate, which means you might be forced to answer questions. You don't have rights against self-incrimination, and generally in these cases, and therefore, because answering the question can help people discover the truth, you have to be able to answer questions when they're presented to you. So, and as I said, there's really no pure case, at least not today, of an inquisitorial system. Generally, the French legal system is considered, let's say, the model of a non-adversarial system. In that case, not all the cases, but in at least the largest cases, there would be kind of an investigating judge, and the judge would collect evidence and materials before the case. And what would happen is the judge would kind of maybe ask follow-up questions or present the case, regardless of what the prosecution was doing. So there wasn't really a separation of prosecution from investigation, which means not a clear line between police and prosecutors. So the judge would research the evidence before the trial occurs, and the judge would decide what issues and facts are relevant. So as opposed to the adversarial system where the judge is just saying, does this follow the correct procedures, okay, and rule on motions made by the attorneys, the judge will decide this is what's important to know. These are the things that are unsettled, and therefore, based upon what they decide are the key issues and the key facts of the case, they might, let's say, ask questions of either side saying, this isn't clear, I need to ask you what you did here, and they would follow up. And therefore, the decisions and the judge kind of drives the trial as opposed to the defense and the prosecutor and the defense attorneys. And so all this blurs this distinction between what police officers do in terms of detectives about investigation, and then the determination and the prosecution of the courts are blurred. Now, this isn't really a legal court, but if you watch, let's say, some daytime law and order shows like Judge Judy, and then if you're older like me, the People's Court, which used to have Judge Wapner, and I think it was Judge Joe Brown, but these are not things that I watch on a regular basis, so I might not know who the current person is. And what happens is you have the two sides, and they come up to the stand, and then the judge basically reads all the evidence, collects the evidence, reads it, and then asks questions to either side, okay? And then, based on it's not like a back and forth, and will determine whether one side or the other can speak, and based upon their answers to his questions, will come to, let's say, a decision. That's much more close to what an inquisitorial process might be. And once again, that's a TV show. And generally what happens is both sides waive their rights to a legal trial to be kind of, let's say, allow the judge in that case to be kind of the arbitrator or the mediator of their dispute. So in inquisitorial systems, generally you're guilty until proven innocent, which means that the defendant has a chance to defend themselves against charges, but the assumption is that because there's a trial, because there's a significant amount of evidence against them, that they're basically guilty unless they can prove otherwise, which is the opposite of what would happen in an adversarial system, where you're innocent until proven guilty. Now, while the judge is very passive, or basically kind of stand back, kind of a neutral umpire in the adversarial system, the judge is quite active in most inquisitorial systems. They not only decide what are matters of law, but often they can make decisions about what are matters of fact based upon their answers that different sides give, based on their own research. And what the judge can also do is interrogate the witnesses and evidence, which means that if the judge thinks that one of the attorneys is not asking the right questions, the judge can ask the question for them. So the point is the judge can interrogate the witness, they can evaluate the evidence, they can collect evidence on their own. And this is a very different process than what most people see when they watch American law and order type of shows. And in some cases, although this has changed for the most part in recent years, you might have not a jury of your peers, but you might have a professional jury. So you might, if to the extent that you even have a jury, the jury might be made up all of lawyers, which means that in Japan, until about 20 years ago, in criminal cases, the jury was made up of lawyers. And as a result, they were not easily persuaded of things. They understood what the law is. They generally would be more educated. And not surprisingly, and the reason why this changed is that the conviction rate in Japan was well into the 90% in criminal trials, because the lawyers generally understood the law. The defense attorney's ability to kind of talk about non-legal things in terms of their defense did not sway this jury, and they thought it was too friendly to the prosecution. And by being too friendly to the prosecution, the trial was less fair. And actually, Setsu Miyazawa, which is someone I work with, is someone that pushed to kind of change the trial system in Japan and lead to more jury trials as a way of, let's say, improving the rights of accused in Japanese criminal cases. So just another way of just kind of visualizing the differences between adversarial and inquisitorial system. In an adversarial system, the defense has a lawyer, the investigation has a lawyer, which means a prosecutor, and then you have a decision that might be that's overseen by a judge, which means in the trial, the judge will make decisions. In an inquisitorial system, the judge basically moves in and becomes the investigator as well as, let's say, the adjudicator or the person who's making the decisions at the trial. So the role of the judge is much larger in the inquisitorial system in terms of the different roles in a criminal trial. So what are some of the strengths and weaknesses of the adversarial system versus the inquisitorial system? Generally, the adversarial system is a lot more favorable to defendants, while the inquisitorial system is much more favorable to the prosecution. Now, that might be good or bad depending on which side you take on individual cases and what you see the basic problem is. Many people feel that the adversarial system allows guilty people to go away because they can get off on technicalities, and that's not right. While the inquisitorial system basically makes it really unfair for people to defend themselves, and even though they're able to get convictions relatively easily and put maybe guilty people into incarcerate guilty people, they might also, let's say, incarcerate many innocent people. And particularly in my experience, Japan just actually in the last few months changed what are called, falsely accused cases, where they changed the things about the interrogation to be more like the United States, from a system where you once had someone who was on death row for like 70, 80 years, falsely accused because they confessed to something they didn't do, because the interrogations were so empowered to kind of put pressure on them to make confessions, even when they were innocent. So in the adversarial system, the lawyers are in control, and this means that criminal cases are very expensive because lawyers are not cheap. And it can also mean it's really time consuming because lawyers can make a variety of different motions, which means that they can make motions to delay, to reschedule, to continuances, to research evidence, to object to different, to form the, pick the jurors. All this makes these cases much longer and time consuming, and therefore you might have a backup or delay in justice because there's only so many courtrooms and only so many judges to hear cases, and because lawyers are making constant motions and some of these motions are quite complicated, in an adversarial system it's going to be a lot more time consuming. When you have the judge in control, the judge decides what's important and which means that this case is going to go relatively quickly. If it's a pretty straightforward case, they're going to be able to ignore whatever motions or not consider the motions of lawyers because they're going to decide what is important based upon what they think are the key issues in the case. And as a result, these cases can go very, very quickly, especially if it's cut and dry. Adversarial system, the quality of your lawyer, and particularly in recent years, has become really vital, which means you might be convicted not because you're guilty, you might be convicted because your lawyer is not adequate or is not as good as, let's say, the prosecution. And in the same case, if you are wealthy and at resource, you can hire a much better defense attorney and be able to outspend, let's say, the public prosecutors, and that might force them to, let's say, plea bargain or dismiss charges, not because you're innocent, but because the public system doesn't have enough resources to pursue, let's say, a prosecution against a well-heeled or a very well-lawyered defendant. Lawyers play relatively little role in the inquisitorial system because the focus is on truth, and therefore there's going to be less about the technicalities of the case and aspects of the criminal procedure and aspects of it, including or excluding evidence. The adversarial system, the jury system, is relatively passive, as I said before. They only see what is presented to them. They can't ask questions about what might be in their head, about what they would like to know more about to help them make a decision. It is more democratic in terms of that, quote unquote, it's randomly chosen members of the public. Now, with a lot of, motion to strike jurors from cases, I'm not sure how democratic or how random it is, because with a lot of the evidence and particularly statistics and big data, people generally know what types of, by demographics, what jurors are more likely to convict and what jurors are more likely to acquit. And as a result, there's a lot of, let's say, resources put into making, designing the jury that's going to get you the outcome that you want, and therefore that might be less democratic than the original conception. In inquisitorial system with non-jury trials, you have the case where you might have detached judges or professional judges who are lawyers themselves, and they rotate through different juries in criminal cases. As a result, they know the law, they might be better educated, and they might be better able to handle the factual, let's say, information in the case. So particularly when you have more technical information in forensics, you need to have either well explained to you, or you might need to have a background to be able to understand what different things mean. And it's become, I think, once again, to go back to the O.J. Simpson trial, there was a lot of forensic evidence presented, but it seemed that either it was above the juror's head, and both sides, both for it was technical, both on the defense and also on the prosecution. And ordinary people don't have that background, even people who are well educated and people who are highly intelligent. So the key thing in the adversarial system is that you can exclude evidence, which means evidence can be, the jury won't hear all the evidence if it's collected improperly, if there's not collected under a warrant. And most of the evidence is testimonial evidence, which means you listen to the evidence. And so what's going to happen is the jurors will sit there and listen to different witnesses and to their questions. And this means that what they get can be chopped up. And because when we talk, we sometimes leave out some of the information and we're not as precise in terms of what we describe, even though good lawyers will try to ask questions that will elicit, clear answers. While in an inquisitorial system, all the evidence is allowed because any evidence supports the search for truth. Even if it was illegally obtained, even if, let's say, it helps out the defendant, the idea is that the more evidence you have, the better decision you would make. And most of the evidence is in written form or in exhibits or trials or documents or diagrams. And so the point is that what you have is the judge or the professional jury is going to read a lot of evidence. They're not going to, and they might have affidavits and things that are written down. You're not going to listen to witnesses at the trial itself. So as I said, that adversarial system is generally better for the defendant. They have a right to remain silent. They have a right against self-incrimination. The standard for conviction is higher, so a reasonable doubt means not guilty. So you're not declared innocent as so much as not guilty. And what generally happens is that you can plead guilty, and there might be a plea bargain, which means that if you basically save the time and the expense of carrying out a trial, they might agree to a lesser charge by saving resources. In generally inquisitorial systems, you are not allowed to have guilty pleas, and there is really no right to silence, because your right to silence is impeding the search for truth, and therefore you might be forced to answer questions regardless of, let's say, whether you want to or not. And that changes things a lot. So, for example, in Japan, their right to remain silent is quite different, which is they have a right to remain silent, which means you don't have to cooperate or talk to the police. However, when you start talking to the police, if you initiate cooperation, which means if you come down to the police station, if you start answering questions, you have to continue to answer questions. You can't decide in the middle of the questioning that, okay, I don't want to answer any more questions, I want my lawyer. And as a result, the point is that once you break your silence, okay, you can't stop. You can't return to silence. While in the United States, generally the standard is you have a right to remain silent that you can exercise at any time during, let's say, the investigation or during the trial. There's also sometimes whether you have a right to remain, your right to remain silent is just limited to the investigation, which means you have a right to remain silent to police investigators, but you don't have a right to remain silent, the right to remain silent only applies to the trial, but it does not apply to the investigation, which means that if you look at the due process, the right to remain silent in the Constitution is mostly dealing with, things that would pertain to the criminal trial, and therefore the police, it doesn't apply to, let's say, police investigations. Generally, that's not what the Supreme Court has held, but you should remember that there were very few police organizations when the Constitution was originally written. And basically the court was the criminal trial was the investigation. There wasn't, let's say, a separate investigatory arm of the criminal justice system. Okay, so I want to talk a little bit more about what victimless crimes, and let me just say off the top, calling something a victimless crime does not mean there are no victims. It means that the victim is generally either not aware that they're not aware because they're not present in the commission of the crime, which means that the victim is some third party or someone that's not directly involved in the crime, or that the victim is society in large, which means when people collude or do something, they're perfectly fine. They don't feel victimized, but generally larger society is the larger society is the victim, which means if you vandalize something, you destroy the environment, or if you use drugs, the victim is our society that might be affected by your individual choices. Now, the other thing is sometimes that the victim, the supposedly victim, is actually a party to the crime, and this is the case with drug offenses, which means that the person being victimized is the person using the drugs, okay, but that person is not going to say, well, geez, I just bought drugs, you should arrest me. They're a party to the crime, and therefore they're not going to, in a sense, give that information or evidence to the criminal justice authorities. As a result, what criminal justice has to do is different in these cases. And if you look at this little diagram on the right, it's just kind of, let's say, a nice flow diagram of determining whether there's a crime. And so, for example, if the victim was society, then that's not really a crime, at least in the view of the person who made this diagram. Generally, what a crime is that there was someone's individual rights were violated, and those rights, and therefore that individual is going to make the complaint to the criminal justice system that will lead to the investigation, arrest, and a criminal trial to determine whether they're guilty or not. Okay, so in a typical crime, you have a perpetrator who then, violates a particular victim. So, for example, if I steal your property or if I injure your person, right, you're the victim of a crime, I'm the perpetrator, and then the victim will generally alert the criminal justice system saying, hey, this person stole my property, this person injured me. And if it's not just the victim itself, there might be a direct witness that says, look, I'm going to call 911 and tell the police there's a crime going on, someone's breaking into my neighbor's house. And as a result, the criminal justice system is reactive. It reacts to someone saying there's a crime, calling the police, and the police come and investigate or make an arrest, or the police directly witness the crime in progress, okay, and they intervene on their own behalf. Which means the point is that there's a clear victim in the case, and that victim feels injured, and that victim is going to make the complaint to the criminal justice system, and then the criminal justice system gets involved in the crime. When there's a victimless crime, the perpetrators are basically maybe colluding with each other. So, for example, if you have a case of a drug case, the drug seller and the drug buyer are both perpetrators of a crime. Slightly different crimes, but the point is that they're both involved in the crimes. There's no reason that either one of them is going to report the crime to police authorities. Same thing with most sex crimes, such as pornography or prostitution, right? The person buying, soliciting the pornography or prostitution, and the person providing the pornography or prostitution is not going to say, by the way, we just committed a crime, you should arrest us. And so the point is that no one's alerting the criminal justice system. So how does the criminal justice system know that a crime is going on? It has to, in a sense, interact or interfere with, let's say, the perpetrators. And the key thing here is that a lot of white-collar crimes kind of also take this structure. Because when someone is committing tax evasion or fraud, generally everyone involved with it has an interest in making sure that that is continued. Or, for example, if you organized crime or terrorism, the people committing the crime are not going to make a complaint because they're in the know or they're benefiting from the crime. And as a result, you have to conduct an investigation to collect the information about the crime. The victim is not going to cooperate with the criminal justice system. So what are generally the large categories of victimless crimes? First one is morals violations, so things like drug use and abuse, right? Because the person buying the drugs and the person selling the drugs, neither one of them thinks that they're a victim or is going to make a complaint to the criminal justice system. The victim, you might say, is society in general and perhaps the user, but the user is either addicted and is not aware of it or is not going to make the complaint. Secondly, things that you might call the general category of sex crimes, prostitution, pornography would fit into this. The person buying it, the person selling it, neither one of them wants to be arrested, and therefore they're not going to report the crime. And generally, these are things that happen outside of the public view. Now, these are not crimes today, but they were crimes at some point, within the last 50, 60 years. When abortion was criminalized and homosexuality was criminalized, they were kind of treated under this heading, which means that you would have raids, or you would have, let's say, people would arrest mothers or doctors that were performing abortions. They had raids on places where they were suspected people met for homosexual interactions. And so these were kind of treated on the heading. In general, these are not criminalized. Obviously, there's a lot of things in the current news about the status, at least, of what abortion rights are in this country today. So this may change in some aspects. But the point is that they still were kind of a victimless crime because the person, the people engaging in the activity, no one thought that they were being victimized or violated. Gambling, especially illegal gambling, so gambling online or sports betting, generally the person making the bet and the bookie, neither one of them is going to report their activities to the police. Suicide, and a lot of people say, well, why can the police stop someone from committing suicide? What are you going to do? Kill them? The point about that is that they're not a victim. They're making a choice. They're acting upon themselves. But the reason why generally it's a crime is so the police can intervene. Other things like vagrancy and loitering might also kind of fit under this general category of morals violations. Traffic citations, so speeding. Very few people driving fast think that they're criminals. The point is that very often people don't report them, and even when you report them, they can't necessarily identify an individual car. So the point about this is that there's no clear victim when someone's speeding and an accident hasn't occurred. When an accident occurred, there's clearly a victimized person. But if someone's speeding, i.e. breaking, let's say, a posted speed limit, but no accident has occurred, it's arguably that there isn't a victim, at least not a victim yet, other than, let's say, the annoyance of driving on a road where people are not following the rules. Organized crime and terrorism. And there's something called RICO, which is a way of prosecuting criminal organizations and conspiracies, but generally all the members of the organization, whether it's a gangster, organized crime, mafia, or whether it's a terrorist group, everyone who's part of that and has direct knowledge of the crime is basically in on it or has a reason for the information not to be discovered. And lastly, white-collar crimes, so things like fraud, when people misrepresent things, like they're people who are trying to legally evade taxes, people who are downloading, let's say, pirated content off the internet, movies, music, other types of things that have what are called intellectual property rights. When people violate that, particularly whether you have websites that generally have this material out there illegally, and then the people who download it, neither one of them thinks they're committing a crime. And I've heard in this internet age, you hear every type of reason why someone's use is okay or doesn't, let's say, fall into that category. So what are the problems that victimless crimes create? the thing is that, first of all, that most people who are incarcerated, most people who are in jail and prison, are in prison for victimless crimes. The largest category here are drug-related crimes, like what you might call non-violent drug offenses. And so the problem is that the incarceration problem in our country are mostly for crimes where the person who was arrested did not think of themselves as a victim. And that creates a huge problem because it's a burden upon our prison and jail system in this country. But the bigger problem is that what it forces the criminal justice system to be interventionist, which means it's not just reacting to people making calls to the police or calls to service or reporting crimes. They are looking for crime, which means there's almost in the sense that they think there's crime out there and they have to find it. And as a result, this leads to a variety of different practices that lead to corruption and abuse, so undercover policing. And even in the case of, let's say, traffic violations and speeding violations, where you'll see police cars that'll have like white on white markings or black on black, so that it can't be easily identified as police vehicles, where people for speeding, they're trying to catch you committing the act, as opposed to, in a sense, the previous standard. And if you go into other countries, that police cars really stand out in a crowd because their markings are so identifiable, because the police car is basically there to encourage people to drive safely and to remind people that they're being watched, and not to, in a sense, be kind of in hiding and have what we often call speed traps. It leads to things like undercover surveillance. This is something that happens a lot in the United States. In other parts of the world, these are completely illegal, or they're really, really strongly limited. Any type of, let's say, wiretapping in Japan is associated with the political police and the fascist police between World War I and World War II in Japan and Germany. And as a result, they have really strong limits on what you can do for undercover surveillance and bugging. It leads to informants, which means that you might have people who are committing crimes, but because they cooperate with the police, or they cooperate with the police, or that they're providing information to the police, they are not arrested. So more or less you create a system where some guilty people are allowed to continue on their guilty activities because they're helpful to the police in other ways that are determined to be more important. And finally, it allows for plea bargains, which means you might find someone who's guilty, you would have a clear conviction, and they're able to negotiate that. In many countries, in most civil law countries, you're not allowed to have plea bargains. You're not allowed to say, well, geez, yeah, you got me, but I can give you information on someone else. And the reason why plea bargains and informants come up in victimless crimes is because they're sources of information on things that where there's no report, or where the police need to collect information on things that people are trying to keep out of public view. And if you think of this in terms of business crimes, is that when a company does something illegal, or breaks the law, or is fraudulently preparing, let's say, their financial information, okay, the only people who really directly know about that are the people who work in the company. And so generally what happens, and this goes either for both organized crime, but also, let's say, white collar crime, is that you get someone in the company on a different crime, and then use that as leverage to get information on another crime. And so this leads to a lot of absolutely problems associated with discretion, which means prosecutors and police have the ability to make a decision whether to investigate or not investigate, who to charge and not charge, and this allows them to kind of pick and choose who the guilty people are and not treat everyone the same way. And this can, this is not necessarily racial profiling, but this also allows for the possibility of profiling people, or determining that some people are a greater threat to society. So just as a reflection, hopefully this kind of fills in some of the gaps, and particularly puts the American system in the context of other systems that are different, and show what are the advantages and disadvantages of that. So I'm going to end here, and I will see you in class, and I'll see you in the next video lecture. Bye.